on your give attention and you shall be heard. May God save the United States of America, the state of Florida, and this honorable court. You may be seated.
Good morning, everyone, and welcome to a session of oral argument in the 5th District Court of Appeal. As you've already heard, I'm Judge Griffin. To my right is Judge Torpy, and to my left is Judge Jacobus. We have an abbreviated docket this morning. We have only 3 cases remaining, which we will hear in order. The third case will call for a change of panels, so we'll take a brief break after we've heard the Heathrow case. The first case is Stiles v. State. It's a criminal case, so as you know, you've got 15 minutes per side to argue. Heathrow is a civil case, so you have 20 minutes per side to argue. There's a clock at the podium, and if you need any help with reserving time for rebuttal, let me know. I see that everyone's in place for the first case, so we'll call it Stiles v. State of Florida.
Good morning. May it please the court and counsel, and I'd like to acknowledge that my client's parents are also in the courtroom this morning for the oral argument. And Judge Griffin, I would like to reserve 5 minutes, if possible, for rebuttal. And to the extent that I don't have time this morning to address all the points in my brief, I'd like to, with the court's permission, rest on the briefs. And this appeal is from a criminal trial in which Jeff Stiles was charged with first-degree felony murder and attempted armed robbery, which was the felony.
Are you going to address the reputation evidence issue first?
Yes, sir.
Okay. Let me just ask you, kind of as a threshold point, when there is an issue, a factual issue, over whether a witness is sufficiently familiar with someone's reputation to offer reputation evidence, is the resolution of that factual issue one for the jury or for the judge?
I think as a first step, it's for the judge. The judge is gatekeeper of that admission of that evidence. And here, in terms of,
in other words, they say on direct. I mean, the foundation is fairly easy to lay. You know, are you familiar with this person's reputation in the community for veracity, or whatever the character trait is? And they say yes, and ordinarily they could go into that, but in this case there was a little bit of an unusual procedure in that there was outside the presence of the jury, they proffered the testimony, and there was a cross-examination. And it seems like from reading that cross-examination that the witness was impeached somewhat. Would you agree with that?
Yes, Judge Torpy, but I think there, in terms of your first question is jury question, judge question. In terms of meeting the foundation, that's a judge question. The cross-examination to impeach it, to show that there's a weakness in it, that's a jury question. Mm-hmm. So I think once the...
Well, what happens if the judge decided, based on this cross-examination, that he didn't believe that this witness was familiar with the victim's reputation for violence?
Well, if the judge made that finding as a credibility matter, mm-hmm. then I think the judge's finding would be subject to, it's virtually unreviewable. It had to be clearly erroneous. And I think in terms of to the extent the court is making fact findings, in terms of the predicate for the foundation, that is the applicable standard. But the judge didn't make a finding that Megan Delettra was not credible. Instead, I think because the proffer extended over such a period of time, and then when the state attorney was addressing the court in the final moments as to what had been shown and what had not been shown, the state focused on specific instances of violent conduct, or the state focused on specific answers to...
But the trial lawyer said, we're not going to go into that, didn't he not? I mean, he told the judge that's not going to be part of the direct testimony before the jury.
And as I believe I put in my reply brief, Judge Jacobus, I mean, if there was a problem with the specific instances or any other matter, that could have been limited by either the judge making...
Let me ask you that. It seemed to me that the trial judge got confused on the length of time that, what's her name, Miss Delettra, knew Mr. Wilson's reputation. She said 5 years in the proffer, and then on cross-examination, she kind of said 3 years, and then it seemed like the trial judge got hung up on the time they were in school together, which was like 4 months or something.
Yes, exactly, and that was what I was trying to answer with Judge Torpy there. I think the judge got confused in terms of what the state attorney, I don't think the state attorney was trying to confuse him, but I think they got confused as to what the state of the evidence is. I think the findings, to the extent their fact findings were clearly erroneous, that got more to what was her personal opinion. Her basis for her personal opinion may have been more limited, but her basis for the...
Well, what does the community have to, I mean, he seemed to say, well, I don't think the community's big enough, like party goers or something, I think he said, but, you know, I mean, you think that's...
Well, the community they established was this...
I mean, do we look at what, I mean, the trial judge obviously thought it was not, you know, they didn't lay the foundation, I think is what he thought, really.
Not broadly enough based was his conclusion, but I think the conclusion just isn't set. The record doesn't support that conclusion. I think the trial judge simply got confused because it was a lengthy proffer, because of the cross-examination. He was confusing what I'd say was a basis for her personal opinion, which wouldn't have been admissible anyway, versus the basis for her knowledge of his reputation in the community generally, which was extensive because they went to the same school, they lived in the same...
But they only went to school for like 4 months together, I think. But she seemed to know more about him, I think, for
yes,
about 3 years.
I think the going to the same school indicates it was a school of 3,000 people, and she indicated, I think, between 40 and 100 people she had heard his reputation. So it's people out of this school community that she then sees at parties and hears about his reputation. So I think...
Let me ratchet you ahead to your
Yes,
803-3A2
Yes,
issue, if I may. What...
I feel like I'm in federal court with shooting numbers here at me, but go ahead, Judge.
All right, sir. But what was the testimony about what the victim had told the friend? Was that relevant?
It was, I would agree with the state to the extent the state said it arguably was relevant to show identity, and as the trial judge, and I thought the trial judge made an excellent record here, you could limit, though, the testimony. The judge can give an instruction, the witness can say, Mr. Hammers could say that the victim told me is going to meet the defendant. So it's... Well,
I mean, whose job is it to ask for a limited instruction on that? If you're offering a statement and maybe only one part of it is relevant, and whose job is it to ask that it be limited?
I think in the back and forth, Judge Torpy, in the proffer here again, the defense did agree that it would have been admissible for identity, but the argument then turned on to the state is seeking to admit the further statement that Hammers said the victim told him he was going to buy drugs from the defendant. And as the defense said, and as the judge seemed to agree until his final ruling, that really was the only relevance of that was, or what the purpose of admitting that is to show not the subsequent conduct of the declarant, but the subsequent conduct of the defendant is clearly not admissible for that purpose, and yet that was the only relevant purpose there.
But can the whole statement come in, notwithstanding the fact that part of it is relevant and part of it isn't relevant?
No, sir.
It was one conversation. It was one statement. The victim said, I'm going to meet Stiles later to buy drugs from him.
Well, in terms of, say, the rule of completeness, if the state had sought to only admit part, and the defense says, out of fairness, Judge, rule of completeness, I want the whole statement to come in, then yes. But when the state isn't permitted under the rules of evidence to admit the whole statement, then the defense could stand by, well, Judge, if that's your ruling, then, but limit the admission to just the identity, not the purpose of the meeting.
Does the fact that he was going to buy drugs bear circumstantially on the manner of death? I mean, can you draw an inference from that you know, people when they go to buy drugs, you know, they're ripped off. It's a, you know, there's a lot of violence in these kinds of transactions, and is it relevant for that? Well,
but the conduct, though, that statement, it's a statement of state of mind. That's the exception that's going to come in under 9803 3A. The conduct has to be the conduct of the declarant. And then is the conduct of the declarant here, what's it being proved by this, or the conduct of Mr. Stiles, the defendant, that he's there to sell drugs to this person, and therefore he knows...
Well, you know, under that exception, you're always going to show both the conduct of the victim and the conduct of the defendant. I mean, the example that Professor Earhart gives is a victim saying, you know, I'm going to go spend the afternoon with Mr. Smith. Well, that shows both what the victim is planning to do And it also suggests that Mr. Smith was, was present with the victim, right? I mean, doesn't it do both
Yes,
things?
Judge, I would agree. This is one of those sort of almost metaphysical problems that sometimes it seems difficult to understand.
It seems to me that the focus really is on whether it's relevant, because you get into these cases where the state tries to show, what the victim said, to show the victim's, quote, subsequent conduct, and the subsequent conduct has no relevance to any of the issues of proof that the state needs to get into. And that seems to be where it's more problematic.
Problematic in terms of determining, say, 403, the relative prejudice versus the relevance here. The defendant himself was already conceding he was going to meet this man. The defendant himself was conceding it was a drug deal. The only dispute was who was selling, who was buying. And so that, I think, then it becomes more prejudicial than probative. And so in terms of resolving this, typical metaphysical split. It's going to show both. I would agree.
Every time I look at those 403 issues from the perspective of an appellate judge, I'm hard pressed to find cases where an appellate court reverses a trial judge on that issue of probativeness versus prejudice.
I think, though, Judge, if we look at, the trial judge who was there, let's say, did make an excellent record, and I think we see his thought processes, which was very clear. And he does seem to be correct as he leads the state through, keeps trying to get help from the state. How is this not more that you're proving the conduct of the defendant than the state? And there never was, in my view of the evidence or the record, a satisfactory response to that. So I think it is an abuse of discretion in this case because it was so prejudicial amount of time. If I could eat into my rebuttal time, I'd like to go forward. Just on the knife. The knife issue is very important. It's, of course, fact-bound. The important fact is that the knife was found, according to the detective at the scene of the crime, folded up and in the victim's pocket, and the medical examiner's testimony was the victim would have expired within 5 minutes and lost consciousness in a little over 2 minutes.
Do you acknowledge, though, that there need not be a chain of custody in order to authenticate some piece of physical evidence?
Yes, sir. Yes, sir. The question is it in substantially the same condition? Because it then became... when it was discovered in the middle of the trial, this knife that's now the state's putting into evidence can't be folded shut easily. It had to be, in effect, forced shut. That just defeated the defense argument that it's self-defense. The victim had pulled this knife out and swung at the defendant. But then how is that consistent? Well, the knife is found then on the dead man's body, folded up in his pocket, and he only had 2 minutes and he's just been shot. If the knife is a new knife, just folded shut as knives do, well then fine. But if you can't demonstrate to the jury that this knife folds readily shut, you've just lost your self-defense. And so I think there's no dispute the knife couldn't have been in substantially the same condition. No one could testify that it was. The detective, who was the one who took the knife into evidence, said he could not testify it was in substantially the same condition. There was evidence from the father who had had custody of the knife for the intervening year that he had used it on his job, on his work as a concrete man, and that it was constantly wet and so on and so on and so on. The tip of the knife had been broken in its use at work and so on. So I think it's clear the knife wasn't substantially in the same condition. The state hadn't met the necessary predicate. This was so prejudicial to the defense that this alone is reversible error. And just finally, in 30 seconds on the sentencing question, I draw the court's attention in my reply brief. I did find, in response to the state's argument that the record wasn't clear. The state was saying that it wasn't the trial judge who had initiated the plea discussions. I found a better reference, which is in my reply brief, where it's clear that the trial judge did initiate, from his point, from his side, the attempted plea discussions. And the prejudice is obvious here because the trial judge threw out the concept of 25 years. Then when the jury comes back on a lesser of manslaughter and the guidelines are 11 years, the judge imposes 25 years. I just think that one doesn't give due respect and accord to the jury's verdict, but it's just a classic example of what the Supreme Court in the Warner case prohibited. Thank you, Your Honor.
Thank you, counsel. You've got about 2 minutes left.
May it please the Court, my name is Chris Davenport and I represent the state of Florida. To start with this reputation issue, The trial court made a finding that this was not a sufficiently broad-based community to allow this kind of evidence in.
Did the trial judge get confused on the length of time, though, do you think? I mean, it appeared to me that maybe, she said 5, there's no question.
Right.
Then, kind of on cross-examination, she said, well, maybe it was really 3, and then the school thing was like from August to December, I think. And the judge kind of seized on that.
Well, the witness, the first time her testimony was proffered, she said, oh, I knew the kid from school. We went to the same school
Right,
together, and I knew him well there. I knew who he hung out with. And then on cross, it turned out, well, she was there for 3 months, and it kind of looked like the defendant was there for about a week.
It was August to December, I guess.
So she was severely impeached on that. I think if anybody got confused, it was the witness. So then they brought her back.
2 years, too. I mean, she went to 3,
she went from I knew him for 5 years, and then the whole school thing fell apart, so she came back a little later and said, well, I knew him from these parties that we attended. Again, I never talked to him, but people said that he brought the drugs.
That's kind of how you get reputation information, though.
Right.
You may not know the person.
That's a lot of effort by the government to keep out, some testimony that probably
Wouldn't have made a difference.
To the jury from standpoint.
I totally agree with that, Your Honor. They really fought this, and it's harmless error even if it should have come in.
Might have been better off impeaching the lady in front of the jury rather than doing it in a sidebar, too.
I think in hindsight that would have probably been a good strategy. I mean, she's not the most credible witness. It's the defendant's girlfriend. She testified, I'm going to stand by him, and so,
What do you say about counsel's subsequent conduct hearsay issue, that and specifically that part of the statement made by the victim that goes to who was buying and who was selling the drugs, and what's that relevant to? And
well, first of all, let me say that the objection below was to the entire statement. They didn't try to carve off who was buying, who was selling. They didn't want any of it to come in. The statement itself was relevant to put the victim with the defendant and the victim bringing money to the transaction. Somebody who's going to go buy something brings money. Now, there was an attempted robbery charge here. So it's relevant that that was the plan. If he had said, I'm going to go sell drugs, that kind of takes away from the robbery argument because, well, although the other guy would have, it would take away from the robbery argument because the defendant would have presumably been going there with money versus with the drugs to rob the guy. So it is relevant to the robbery argument. And as Earhart points out, if the statement is, I'm going to go do something, it's relevant to show that the victim went and did that. So it's relevant to show he went and met the defendant with money along. To the extent that it shouldn't have come in, again, it was clearly harmless error, especially in light of the fact that he wasn't convicted of the attempted robbery. The jury hung on that charge. That's what that kind of evidence went to. So
what do you think that Taylor case means? That Supreme Court case where they kind of as an aside talked about whether or not this evidence is admissible under the subsequent conduct exception of the hearsay rule. What do you think that case means?
Well, and then where you're talking about, because they said it's not relevant to show what the defendant did, it had to be relevant to show what the declarant did. I think in this context it is relevant to show what the declarant did. We didn't use it to say the defendant did something. We used it to put the victim going there with money. So the issue below, as defense counsel argued below.
If it shows both, is it admissible?
No, I think as long as it shows what the declarant was going to do, that makes it admissible. And of course, when there's these intertwined transactions, it kind of is going to show what the defendant is going to do too. But as long as it's admitted to show what the declarant does, that does make it admissible. In the Taylor case, it was admitted just to show what the defendant did, and that's not proper. Here it was to kind of show both, but it was a side thing because they're intertwined.
To show what the declarant was planning to do, and it also has to be relevant to the state's case, right?
Right. But it's relevant that he was going to go meet the defendant, and it's relevant he was going to go there with money. And it also, in some ways, rebuts self-defense because he went there intending to buy versus, the defendant's position was he went there, the guy was trying to rob him. He pulled out a knife, wanted his money, stuff like that. So it was kind of relevant to that. But it was admitted to show that he went there with money. The issue wasn't who went there to buy and sell. The issue was who went there with money and who went there with a weapon. So it's all intertwined, but it's relevant to that. As far as this knife goes, as the the defendant's father said, yeah, I broke the tip off. It opens the same way now as it did when I got it. I used it. I'm familiar with it. It's substantially in the same condition. That makes it admissible. It's a jury question whether they wanted to believe defense counsel's argument. How could it possibly be the same? He used it for a year versus the father's testimony. It works the same now as it did before. So clearly that was relevant evidence. As far as this vindictiveness claim, the trial judge has the right to say, are there any plea offers? They have the right to urge the parties to reach an agreement. What they can't do is say, if you don't take this plea, you're going to get a higher sentence after the trial, or here's my offer and this offer isn't going to last through the trial, or something like that. And the judge didn't do anything like that here. He wanted to make sure everything was on the record. He wanted to make sure the parties were talking. That's entirely appropriate for the judge to do that. He also put on the record at sentencing why he gave the defendant the sentence he did. He said he brought this gun, he pulled the trigger, but he cocked it and then pulled the trigger. This was a really dangerous thing. He explained his reasoning, and it had nothing to do with, gee, you should have taken this plea before trial ever started. So the trial judge didn't do anything improper there. There's no vindictiveness in the sentence. And we would ask the court to affirm. Thank you.
Thank you, counsel.
Thank you, Judge Torpey, for drawing the state's attention to the Taylor case, because I cited that pages 45 and 46 in my brief. I think it is probably the most important case on that point, because the Supreme Court, I believe, they're reversed because they were focusing on what was the state's real interest in introducing the evidence, and that's the same here. And I think the trial judge brought that out well in the record.
But you know, in Taylor, though, I don't know how the state could argue that they were offering it for this purpose when they didn't even make that argument below. I mean, they said that it was admissible under the state of mind, exception to the hearsay rule, and there wasn't a state of mind issue in the case, right?
Well, there's not a tipsy coachman kind of.
Well, it's hard to make a tipsy coachman argument, though, when you're seeking to argue that a particular piece of evidence was offered for a particular purpose, for a limited purpose, when they didn't offer it for that limited purpose below.
In terms of the real interest, though, I mean, being, I think, a fair reading of the record, if the jury accepted this statement, then the defendant's testimony could not be true. And so it went so far beyond any purpose of showing identity or that he was there to buy drugs. There was no question this was to be a drug deal. And rip-offs can go both ways in drug deals. Would-be buyers can rip off sellers and vice versa. So what it really went to, the key purpose and function and effect of this testimony was to undermine the credibility of the defendant. I'm out of time. Thank you, Your Honor.
Thank you.